Now, as far as housing finance sector is concerned, we saw that the principal regulation that governs the working of the housing finance companies is the RBI regulations. Now, apart from this, there are other acts and other statutes also which have an effect on the working of the housing finance companies. While acts like the PMLA, etc., have somewhat a direct impact on the housing finance companies because they are supposed to implement it on their own, there are ancillary acts which do not primarily apply to a housing finance company, but in a way have some effect on housing finance companies, which is the RERA, which was passed in 2016. It is in effect from 1st of May 2016. Now, RERA is a central act, but all the states also have a role to play. The reason why the states have a role to play is that land is a state subject. So for all those who do not have a background, the Constitution of India lays down 3 lists, which is the union list, the state list, and the concurrent list. Union list is all those subjects or all those things on which the central government has full right and authority to pass legislations and to take actions. State list is something on which the state governments have full right to take actions. Whereas the concurrent list is something where the center and the state both have right to take action. Land is a state subject, and under this act, the RERA Act enables the states to form the RERA authorities. This is the authority which will be formed for each of the states, and each of these states are supposed to ensure that this authority is given enough powers to ensure implementation. Why was this act needed in the first place? The reason is that real estate is a complex subject where there are individual buyers and there are builders. So there were situations where the buyers were not given what they were promised. There were complaints that they had, and they were not very happy with the resolution that was there, because the only choice that they had, if at all the buyer did not fulfill his or her promises, was to approach a court, and then the proceedings would go on for years together. Plus there were other things also which the government considered, like each builder would declare the prices for a particular property in different manner. Like someone would give the prices per square feet of carpet area, someone would give per square feet of built up area, there were concepts of super built up area, etc. So you did not have prices which were comparable in nature. That is why this act was brought into effect, to ensure more transparency, more disclosure, and to protect the home buyers of their interests. Now, what this act aims to do is that once this authority is set up, all the projects which are there have to be registered on the website of the RERA authority of that particular state. This registration has to have multiple details, such as the name of the promoters, the details of the project, how many apartments or flats are going to be constructed, how many car parkings are going to be there, how many of them have been sold, how many of them are unsold, what is the date of completion of the project, when will the builder give the possession of the property, whether there are any litigations which are going on the land, whether there are any other litigations going on, what is the history of the promoter or the builder, whether there are litigations going on the builder or their directors, etc. So that when a particular person is buying a property, he or she has complete information on the project and is consciously taking the decision to buy or not to buy. Even after the booking is done, the RERA says that if 10% of the total consideration has been paid, then it is mandatory for the sale agreement to be registered. Because earlier what used to happen is that people would make a booking, pay up to 90-95% of the price and never register the property. And before registration, they would sell it off to someone else, whereby they saved on the stamp duty and they sold it off to someone else. So they got the profit also, and they never had the property in their books. So to ensure these things do not happen, registration is mandatory. Prices for the property have to be quoted in carpet area only and not otherwise. For each advertisement that the builder gives in respect to the project, the website link has to be mentioned and also the RERA registration number has to be mentioned, so that the person can go to that website, enter the registration number and view the details. There are other provisions also which say that if at all there is a problem in the property that the buyer has purchased, and if there are defects in the property, then within 1 year, if there are defects, then the builder is supposed to ensure that all of these have been made good. The other important aspect that RERA covers is the fact that there has to be an escrow account. What happens is that suppose there is a builder who is having 10 different projects which are going on, and now he is run out of money. So he launches an 11th project. He collects money, the booking amount is collected for the 11th project. The money is actually not used for that project, but it is used to ensure the completion of the project which was stalled earlier. So in effect, it is the new buyers who are funding the construction of a project which was stalled and where they do not have any interest. To ensure these things do not happen, there has to be an escrow account formed for each project. Escrow account, for those who do not have a background, is a bank account which is monitored by the bank. Money cannot be withdrawn from this escrow bank account unless certain compliances have been completed and without the consent of the bank. RERA says that 70% of the consideration has to be necessarily deposited in the RERA escrow account, and 30% has to be given to the builder as free money. So the builder can use the 30% of the money in the way he wants, but 70% lies in the escrow account and it has to be used only for the project and not otherwise. The way to withdraw money from this escrow account is only after a certificate from a chartered accountant has been given and a certificate from an architect has been given. And once the bank has ensured that both of these are in place, will the bank allow withdrawal of the money from the RERA escrow account and not otherwise. So this will ensure that the money is not used for other projects and is utilized only for the project for which it is meant for. Earlier, if you've seen and if you've experienced, there was in all the advertisements, the builders would write a line saying that the plan or the photograph or the amenities that have been shown are subject to change without the consent of the buyer. RERA also ensures that these changes cannot be made until and unless an express consent of the buyers has been made. There is a process to be followed for making these changes, which is detailed in the Act.